Hello, everybody. Happy Sunday. Welcome to the Barbecue Counselor channel. We have a pretty interesting show today. I want to cover a few things. We're going to go a little bit different in terms of cases today. Normally, we spend our Sunday covering the week in review with Reckless Ben, but we've done a couple big videos this week, and check them out if you have not. Yesterday, we released a video on the brand new RICO claims. So Crystal Law and Ben Gorman filed a new set of claims against Bricks and Minifigs. They're now, among other things, alleging that Bricks and Minifigs, Ammon McNeff, and the rest have engaged in RICO violations, civil RICO. So big story, but we put that out yesterday. So I wanted to spend today covering a couple cases that I've been watching and following, but we haven't been able to do some good videos on lately, just with all the Ben stuff going on. The first one I want to talk about is the Lindsay Clancy trial. Now, we'll get into that, but I'm going to take a little bit of a more kind of targeted approach to that. I'm assuming that folks know a lot about what happened in the Lindsay Clancy trial. I will give the background if you haven't, but I don't want to try to do a full recap of everything. We're now at the end of the second full week of the case, or maybe the third full week, and there's just too much for me to cover. But I have been extremely impressed with the defense attorney, and so I wanted to pull out a couple of examples of how the defense attorney's behaved and how he's handled himself, and talk about the strategy going on there. The other case I want to talk a little bit about is the Ethan Klein versus Frogan case. So this case went away and it's come back. And on Friday, Frogan filed a motion to set aside her default. And we've done a couple videos on this issue, but now we've actually seen the brief. So I want to talk about what I saw in the Frogan motion. Am I impressed? Not particularly. Do I think it's going to be enough to get the default set aside? I think it's enough, but it's a much closer call than I think they needed it to be. So we're going to get into both of those, and let's start. I've got a new intro to show you all, so let me show you the intro. So we just rolled that out this week in videos. We many thanks to some of the folks behind the scenes that have been helping me, Colin and Alex. And Alex gave us some great suggestions, and we took those suggestions to someone who could make like a nice animation. So I think it's pretty cool. So, all right, so we'll get into this, but first let's talk about what we got on the smoker. So the fire is ready to go. We are smoking with oak today, and we are going to cook a turkey breast. I have not put the turkey breast on the smoker yet, so let me grab that and show it to y'all. All right. So let's see if this looks okay. Yeah, it looks all right. So we've got a turkey breast here. I have seasoned this with salt, pepper, MSG, and the Meat Church Barbecue Gospel Rub. You can see this. They're not an affiliate. I'm not a sponsor. I just really like Meat Church's rubs, especially on poultry. My wife and I both use the gospel rub. No pun intended. We use the gospel rub religiously when we make chicken. So today we are doing turkey. I am trying something a little bit different with the turkey. Normally a turkey breast lays flat, but this turkey was really mangled and gnarled where the meat was separated from the bone. So I have wrapped it up with a little bit of a twine to give it a to give it the shape of like a loin. I'm not sure how this is going to work. This might make it take longer to cook, but it was just so mangled that I thought, let's give it a try. So let's put this on. I'll be right back. And we are smoking today at about 250 degrees. Normally when I do turkey breast, I'll go a little bit hotter than I would with brisket. Brisket, I normally go about 225 when we start, but with this one, with turkey, I like to go a little bit bigger. So let's first talk about Lindsay Clancy. An introduction. Lindsay Clancy has been accused of strangling her children, a fact that she does not dispute. But this trial she's now being on trial for that. But this trial is not just about that. She has been suffering horrific symptoms of mental illness for many years, I think. The trial has really morphed into a commentary on the Massachusetts mental health system. This is a woman who saw multiple doctors, was prescribed many different medications, and her defense is that she had such severe postpartum depression that it slipped into a psychotic episode, a psychotic break, and caused this horrific thing. I'm not going to try to cover the entirety of that case. It's been going on for 3 months, but I just wanted to give you a background. What I want to focus on is the defense attorney, man with the last name of Reddington. He's a wonderful attorney, just phenomenal when it comes to cross-examination and how he's handling the prosecution. And I wanted to watch with you all one specific issue. I took one witness from the last 3 weeks that I thought best encapsulates why I think that this defense attorney is such a good defense attorney. The issue involves Google searches. The prosecution has made a big deal out of some Google searches that were found on the family tablet. And I don't know if it was like an Android tablet or a Microsoft tablet or whatever it was, but they've made a big deal about some Google searches about self-ending oneself. And it's a story that just encapsulates what happens when you are not careful at trial as a prosecution team, and how the defense can just make you look utterly silly. So we're going to get into that. As a reminder, I am a practicing attorney. I have been practicing litigation for over 15 years. I have been in many trials during that time period. I have seen good trial attorneys and I've seen horrible trial attorneys. And I think that this defense attorney here is among the best defense attorneys I've ever watched. So we're going to get into this. And the first clip that I'm going to play, we're going to watch an initial exchange involving Lindsay Clancy's ex-husband, Patrick, the father of the children. And I don't have the prosecution side, but I do have where the defense cross-examination starts on this story of the Google searches. And so the background is that during Patrick Clancy's direct examination, he was asked some questions about whether he did any specific searches for self-ending oneself. And the defense is going to jump on that. And it's important to keep in mind, this is the very first witness of the trial. So this was day 2 of the trial. Day 1 was openings. Day 2 of the trial. And then the bulk of the testimony we're going to talk about is a computer forensics expert that doesn't pop up until day 13. And so you can see how this defense attorney, in terms of his strategy, is just laying out where he knows is going to go with this particular issue. So let's switch over, and I'm going to hopefully bring this up, and we're going to play it.
Yeah. What happened in September, October of 2022?
Lindsay's mental health started to deteriorate.
And when you say that, sir, what is it that you, as her husband, observed?
Just increased stress and anxiety.
And did she, as a result of that, go to see or reach out for help to see someone?
Yes.
And who was that?
I believe it was Jennifer Tufts.
Now, Jennifer Tufts is a psychiatrist.
Yeah.
And where is she located?
I never went to her office. Somewhere on the South Shore.
Do you remember when Lindsay went to see Jennifer Tufts?
I don't remember the exact date. I think it was sometime in September. I wasn't really involved at the beginning of Jennifer Tufts.
Of course. Do you recall that the difficulties or the trouble, so to speak, began towards the end of September into October of 22?
Yeah.
So what he's doing right here, and we're about to get into the specific questions of the Google searches, but he's setting up a timeline of where Lindsay Clancy's state of mind was leading into these Google searches.
Yeah, it was pretty gradual.
Okay. But do you remember when the DA asked you yesterday whether or not you used your computer to Google suicide in, I think it was August of 22? Do you remember her asking you that question?
Yes.
And do you remember your response?
No, honestly.
You didn't Google that, did you?
I don't think I did, no.
No.
So this was the part that I didn't have a clip for. During his direct examination the day before, he was asked about Google searches about self-ending, and he testified that he didn't Google search. But this is where it becomes really important as a trial attorney to know your case, because what this is going to turn into, it's not actually about a Google search. And the defense attorney knows that, and he's just going to eviscerate this.
But I'm going to show you, sir, a web history of your computer. Have in mind that the question was asked of you as to whether or not in August of 22, you Googled suicide. You responded no, right?
Correct.
The inference being, I guess, that back in August of 22, she would have Googled it, apparently, right?
Sure.
You know a guy named Tim Hall?
I think you mean Tom Hall.
Yeah, Tom Hall, I apologize. Who's Tom Hall?
He's a musical artist.
He's a what artist?
Something else to note about this defense attorney. He moves around the room. And so sometimes it's harder to hear him. And I'll make sure I've got the volume as loud as I can make it. But sometimes it's hard to hear him. But when you're in the courtroom, the being able to have the comfort level to walk away from the podium where all your notes are, where your safe space is, because that's where you've written everything down, and that's where you can cross-reference all the exhibits and things, and you've got your binder and your outline and everything. This attorney knows his case so well, and he's so comfortable in the courtroom, he can just walk away at will. This is a practice skill. This is not easy to do. I have examined witnesses, and I'll tell you, it is terrifying. Your first few witnesses to go an inch away from that dais where all your notes and everything are. So he walks away, and as he's doing that, the jury's attention is following with him, right? Because he's not just standing in one place. So he's moving away, and he walks over towards Patrick Clancy. And so he wants the attention, the jury, to be focused both on him and on Patrick. Now, this is a weird situation because Patrick was called by the prosecution. But if you watch an earlier video I did on this, Patrick was actually, frankly, an excellent defense witness. And so the defense attorney here is kind of treating him like he's a direct examination witness, like he's a friendly witness, but he's also doing the moving around of the courtroom, which is more of a tactic you do in cross-examination because you want to make sure the jury's focused on you. So he's chosen to go by Patrick. So he's standing by Patrick, and now the jury's kind of got their attention on both of them.
Like a musical, like a country artist.
Country. Is he like a guitar playing guy or singer?
Yeah, was.
When you say was, what happened to him?
He committed suicide.
And I'm going to show you, sir, your Surface Pro records.
The fact that this is an artist who committed suicide is central
22.
to this whole issue.
Do you recall Googling the name Tom Hall so you could access one of his new albums or new records?
I do remember briefly listening to Tom Hall's music.
Okay. Now, you've never seen, you haven't seen this document before, correct?
Correct.
All right, and this would be, I'm sure you're probably familiar with it. When you get a phone dump or a computer records dump, you get a printout of all of the sites that somebody would go on, Google, Wikipedia, things like that.
Right.
If you can look to the right,
Yep.
down a little bit, and you see, I think it says Tom Hall.
Yeah.
What is it?
So what he's showing is he's showing a computer extraction, basically the web history from whatever their web browser was on this device. And it's got Google searches, Wikipedia, like your web browser history. So he's got a printout of that. He's showing the guy, and he's leading him towards where he wants to go, which is what actually happened with this artist and the fact that the artist committed suicide and what was actually being looked at on this device.
It says his Wikipedia page.
Yep. Let me see here. So here we've got so that shows you when somebody Googles, and then it goes Wikipedia, and you see where up above it says suicide methods?
Yeah.
Now, you didn't, as you said to the DA, you didn't Google suicide methods, right?
I didn't Google suicide methods now.
But in fact, sir, when you Googled Tom Hall, it took you to the Wikipedia page and it said that he died, right?
He did, yeah.
And then you clicked on the Wikipedia page and it went into a hyperlink. You know what a hyperlink is? I imagine you
Yeah.
do. Hyperlink.
Yeah.
What is a hyperlink, just so I know?
So like in Wikipedia, it would be a word that's highlighted in blue and it goes to a website.
Okay. So if I suggest to you, sir, that as you move down on your searches that afternoon, that you were looking at Tom Hall, that it brought you to ways to commit suicide, Tom Hall, Google search again, Tom Hall, all on that date at the same time. And you were just looking to see about the guy because he killed himself, right?
Yeah, I think so. Yeah.
Get off of this.
So some absolute critical admissions. Now, I'm not sure, this was day 2 of the trial. I don't know if the jury was totally dialed in on this yet. It will it comes back again, day 13 with the forensics expert, but it'll play huge in the closing. So the issue here is he's got a couple things he's now admitted. First off, he's gotten Patrick Clancy to admit that he was the one using the device, not Lindsay Clancy. And second off, he's got Patrick Clancy acknowledging that when he was looking for this musician who had died, that he might have clicked an embedded URL in a Wikipedia page about self-ending methods. So in other words, it wasn't a Google search for this. And the reason why this matters is that the prosecution was making hay about how they were saying Lindsay Clancy had this plan that she was going to do this to her children and then do it to herself. And that these searches were all part of this plan. She was doing it. This was months and months and months before the thing that happened. And so they're like, this was premeditation because she was coming up with this plan. Well, now the defense has gotten Patrick Clancy to basically admit Lindsay wasn't the one looking at that stuff. It was me looking at it because I was looking at this artist.
Any objection?
Can I just see the packet?
Oh, yeah.
And this is going to be totally ridiculous as well. So pay attention. So he's got the packet of the basically the web search that they had just shown up on the screen. He's going to move it into evidence. And before you do that, you have to show your document to the other side. They have to be able to look at it and decide whether they're going to object or not. Rather than just letting this thing in, they've already talked about it. The prosecution makes this, they've got to do this whole rigmarole about looking through it. So let's watch.
Again, Your Honor, I got that discovery from the DA, so it's...
And so he says, the defense, this is what I love about this defense attorney, or one thing I love about him. He knows when to say something and when not. You have to be very careful in a trial what you say in the presence of the jury. If it's not just, even in Massachusetts especially, it's like you say you have an objection, you can't even really say what the objection is. You've got to go off to sidebar. They turn on a white noise machine in the room, and then they talk about it, and then the rest of us never hear what the objection is. But this attorney kind of pushes the envelopes. Reddington pushes the envelope a little bit, and he knows. So the prosecutor's like, well, we got to look at this thing, right? We got to look at this. And so the defense attorney just casually mentions where the jury can hear. All of this is theatrics. A trial is at least 50%, if not 75% theatrics. So this defense attorney knows exactly what he's saying and why he's saying it. He's telling it to the judge, but he's saying it to the jury. This is something that the prosecution gave me. We're just going over something the prosecution gave us. This is their document that they created.
Well, it's an email from his expert, not us.
Just take a look at it and we'll kind of go from there. Hold on a second.
So she's looking at it. She's looking at it. The jury is at this point watching her look at this because they got nothing else to do. So they're watching her go through this page by page. She knows what this document is. She knows what it is because they generated this. They produced it to the defense. And she's just taking forever. This pregnant pause. This is not good for the prosecution.
What is a URL? What does that mean?
Hold on a second.
So again, so the defense attorney, so Reddington, maybe he gets a little bit impatient, but maybe also it's more theatrics. She's taking an absurdly long period of time to look at the little, this is a what they call a Celebrite export. It's a Celebrite is a forensics tool that lets you let you get your data out of your phone. And I've used Celebrite. It generates these really uncomfortable looking tables, but she knows what this is. They created this. Their experts use this document. She knows. She's flipping it over. And so the defense attorney, in order to just subtly emphasize how long she's taking, he tries to ask the next, well, while she's doing that, let me ask another question. Now, you can't do that because her objection is pending. This defense attorney knows you can't do it. And he did it anyway. Why? To emphasize to the jury that she's taking a ridiculously long amount of time because he's already told her, he's already told the jury, this is their document. And she's looking at this like, oh, and one thing I'll add, I don't do criminal trials, I do civil trials. But assuming a criminal trial is anything like a civil trial, they would have had to have identified these exhibits the night before, or at least disclose them on an exhibit list. She knew that this document, if she didn't know it was going to be used with Patrick Clancy, she knew it was going to be used with one of the other witnesses, because you had to put it on a list and exchange it. Shows, and usually before trial, the parties exchange if they have objections to exhibits, so you know. So she's looking at this thing. She knows if they have an objection. I don't know why she's taking so long. She's maybe just trying to be really detail oriented, but trials, frankly, trials are not the place to be detail oriented like this. You have to be detail oriented in other ways, but this is not a good look.
Wait till she gets a chance to finish.
Yes, I would object.
If I could see.
So she looks at it for several minutes, and now they're going to object. And so this is what happens. It goes off into the sidebar, and you can't see anything. So I'm just going to flip through here as long as we can.
Your memory, sir, that back Exhibit E for ID, basically, that would at least refresh your memory, sir, that in fact, inadvertently, that you touched the Wikipedia thing for suicide, but it was for Tom Hall, the singer, right?
Sounds like that was the case.
Okay.
So boom, second big admission on this. Patrick Clancy was the one on the device. Patrick Clancy was looking for this singer. Patrick Clancy is the one who inadvertently clicked on this link. It was not Lindsay Clancy. So problems with this first clip. The issue that I think the prosecution has is they didn't do their homework very well. They went all in on this, and they hadn't done their homework, because the defense, when I saw this, I think I watched this live or close to live when it happened, and I was like, boom, okay, well that's the last. That's the last for us, right? We're not going to see this Google search anymore. But it comes up. It comes up again. So let me cover some super chats really quick before we get into the next chapter of this particular the Google searches issue. So first we've got Zesalex, a member for 1 month. Can't believe it's been a month already. Congratulations. Thanks, Zesalex, for that. He also gifted a barbecue counselor membership. Thank you so much. From Law Nerd Amber, 10 jewels. Thank you. From Weston, 100 jewels. High five. Thank you. And from Panut, 440 jewels. Thank you. By the way, guys, if you've got any questions, any of this stuff you want me to answer, shoot me a super chat or one of these gifts, or if you can type in. I'm not sure exactly how this will work, but drop a quick super chat. That's how I'm looking for questions, and I'll try to answer as much as I can. I have watched almost all of this trial. I'm still like a little bit behind, but I've done a ton of trials. I mean, this, to me, the theatrics of the trial and the way it plays out, that's stuff I love, and I love talking about it. So I'm happy to answer any questions people have on that. So let's jump to the next document. Let me find. Okay. Oh, we're not streaming. 1 second. Share screen. So we're going to jump now to day 13. And who is taking the stand? Well, this is the prosecution, the government's forensics expert. Before I hit play, let me check my barbecue real quick, make sure my fire's still going. Yeah, it's getting low. It was a good time to check. The flames looks like they just died down. That's okay. But I got a lot of really hot coals in here. This is the perfect time to add a new log to the fire. So I think I mentioned this on my last stream. I tend to keep my logs on top of my firebox because it gets them hot and they light on fire faster if they're hot. So we'll just check that for a second. All right, it's already starting to catch. So we'll just close that up a little bit. Okay. Okay, so the government has a computer forensics, and this is where I think Reddington just had a phenomenal cross-examination of this guy. So we're gonna go through the direct, and then we'll go through the cross-examination. I'll give everyone my thoughts as we go through.
Thank you. Good morning. Can you please state and spell your name for the record?
Kyle Paveo, Kyle, last name Pavao,
And where do you work?
Massachusetts State Police.
How long have you worked there?
8 years with 18 total law enforcement experience.
So you worked in law enforcement prior to the state police?
Correct.
And what department?
Town of Mattapoisett.
And are you in a specific role or unit at this time?
I was.
What do you do now?
Now I'm a sergeant in field, assigned to the Bourne Barracks.
And previously, where were you assigned?
I was a trooper in the cybercrime unit.
How long were you in the cybercrime unit?
Roughly 3.5 years or so.
And what is the cybercrime unit?
It's the state's primary child exploitation unit. Assigned to that, or included in that, is also a forensic branch, which deals with multiple other crimes other than child exploitation.
Would it be accurate to state that you are able to examine digital forensics like computers and phones that are related to other cases?
Yes, correct.
Do you have to have specialized training to be in that unit?
Yes.
What type of specialized training did you have?
So I am a certified forensic computer examiner. I'm a certified forensic Mac examiner. I'm a Celebrate certified mobile examiner, and I'm a Magnet certified digital video examiner.
What is Celebrate?
Celebrate it's a company that has proprietary software that parses through data. Most people know it for cell phones. There is a branch that does computers, but it's mostly known for cell phones, extracting data and also parsing that data out.
What about Magnet?
Magnet's the same thing. So Magnet is also another proprietary company. They have software, imaging software. They mainly focus on computers. They can do some cell phone stuff, but they primarily focus on computers.
To be certified in Celebrate and Magnet, did you have to take classes and pass exams?
Yeah, so my...
Let me just pause this for a moment. So it's a little bit kind of slow going here because we're watching the different stages of the direct examination of an expert. The first thing you have to do when you're examining an expert is you've got to set out their qualifications. Not every witness in a trial can offer opinions, what they think what they think happened based on facts. Most witnesses are called lay witnesses or percipient witnesses, meaning you can testify to what you saw, what you said, what was said to you, what you did, things like that. You can't testify to an opinion. So, for example, a good example of that would be like a medical examiner, how a medical examiner thinks someone may have passed away. Well, if that medical examiner didn't see the person pass away, then them trying to figure out after the fact how they think that person died, that's an opinion. Here with computers and computer forensics, it's similar. So he wasn't in the room when these Google searches or the Wikipedia page or whatever was pulled up. So he's looking at the data from the device and he's trying to offer an opinion on what happened. And before he's allowed to do that, he has to set out his qualifications of being an expert in the field or having specialized technical knowledge that will that will allow him to do that?
My forensic computer classes certification is probably like a 6-month-long process. It's 2 weeks of schooling down in Florida. Is then a one-on-one peer review for 4 months, practicals of different file systems and computers. Once you get through that, it then is a practical exam. And then once you pass the practical, it turns into a written exam.
Did you have an opportunity to examine the extraction of a Surface Pro that was seized from 47 Summer Street in Duxbury on or about September 16th, 2025?
I did.
And to be clear, the Surface Pro was seized from 47 Duxbury Street in 2023. It was in 2025 that you examined the extraction, correct?
That is correct. I was provided those files.
And what is an extraction?
So these are actually, it's a computer image. Extractions usually typically referred to as cell phones. So this is a computer image. So this was an actual EO1 file, which is an in-case forensic file. So what it does is it copies out the bit for bit data on the particular drive that you targeted at. And then the in-case file sort of compresses the forensic image. It also adds some metadata to it. You can type in like case files. It keeps some integrity to it.
So is it basically you take a computer or a cell phone and you make an exact copy of the data that's on that cell phone or computer?
Yes. Computers, yes. Cell phones, no.
But you were working on a computer or Surface Pro?
Correct.
And so the extraction for the Surface Pro would be a copy of the data that was on the Surface Pro.
Yes,
Would we
so
say
the
a
image in
Surface
this case
Pro
is
is
a
a
bit for
computer?
bit copy of
I don't know
that
if I'd say
drive.
that.
And when you do the extraction or when you view the extraction, are you changing any of the data?
No, that's why we use these types of images so we don't touch the actual data on that computer.
Did your initial review of the extraction show a visit to a website entitled Suicide Methods on August 23rd, 2022?
It did.
Were you recently asked to look at that visit to that site to get a better understanding of how that website was accessed?
That is correct.
And how did you approach that?
I set a parameter. I went to that artifact that I had previously tagged when I did the initial analysis.
Let me just stop you there.
Sorry.
What's an artifact and what is a tagging?
So an artifact is every single piece of data on that computer is an artifact. So a computer could have 500,000 artifacts, let's say.
And the jury is not getting any of this. This is so dry. A huge problem the prosecution has is their presentation style. You've got material like this that is hard to understand, hard to digest. You need to have some kind of PowerPoint presentation or a slide deck, what we call demonstratives or visual aids, to help guide the jury through this, to give them something they can see that can help them get their heads around this. This is none of this, fortunately for the prosecution, none of this part of the testimony is really that important, but none of it's landing. So
A low end, but as an example. So tagging would be something you would flag that one particular evidence, that one particular artifact as evidence.
So in this case, the artifact was the visit to the website. Is that correct?
Correct.
And then the tagging was just so that you could find it when you went back into the extraction looking for it?
Yes, correct.
And so if you could continue telling us about how you approached that.
So I set a parameter of 12 hours before the visit and then 12 hours after the visit, and looked at the correlating other digital artifacts related to that.
And can you tell us what's a Chrome history database?
So that's so a database essentially, this is a very slimmed down version of what this is. So if you think of an Excel sheet and each Excel page is a section of the data.
I don't know how many people on the jury know Microsoft Excel, but I wouldn't describe a Google Chrome history database. Well, let's talk about Microsoft Excel. Can we just say it's a list of all the things that were looked at on the computer? Boom. How easy is that? You have to work with your experts to like take them from technical world to jury world. That's half of what a trial attorney's job is. It's like, yeah, you have to be able to distill these things down in a way that jury understands. This guy's like, well, we're going to talk about Excel.
Database. So the database would be the whole thing. And there's a scheme or like a roadmap, let's say, of how these pages interlink with each other. That would be an entire database. Everything pretty much has databases. It's just easy for file expansion and disk saving space and things of that nature.
And what about Chrome Web History Table?
So a table would essentially be the Excel sheet that I explained before. It's a
I don't even think that in his explanation for what these things are, that he actually explained what they are. He's just talking about the data structure. So I'm a computer scientist before I became a lawyer. I understand what he's saying. I understand database schema. I've written code in SQL, but it's also called SQL. Before people like harp on me for like mispronouncing things, because I know I mispronounce stuff all the time. I know SQL, SQL, I get it. But listen, what actually is the thing? The jury doesn't give a crap about the database schema. The jury wants to know what is the thing? What is it used for? What is it? What's the information in it? It's the Google history. Can we just say it's the history of the things looked on the Google Chrome? Come on.
A portion of the entire database. That particular one captures, without being a database engineer for Google, who created it, but that table tracks URLs, web page titles, dates and times.
So is it basically a table that you get from the extraction that shows which websites that computer has visited?
Correct. Each table has its own functions on different data it tracks, and then eventually it puts it all together.
And what about a Chrome Web Visits table?
So the visits table
Yes, she
tracks
is trying to get him to explain
things
better,
of
but
where the web
it's not
pages
going very well. This is why you have to prep a witness ahead of
synced to
time.
the device. Were they local to the device? Are they?
I want to
typed?
pause.
Was it
1 second.
generated? Was it gone there through a hyperlink?
So basically, is it?
I want to address something that I saw here in a comment. So Nailhead says he's trying to sound smart, like it's too complicated for the jury to understand. That I think that's right. But here's the problem with that. Juries don't like to be talked down to. Explain it to them. I had a trial about 1.5 years ago. We were in Texas, and it was a software case. And in a software case, especially when it's intellectual property like this was, one of the things you have to do is you've got to show the jury the source code. Source code. So I'll try to distill this down. Source code is essentially the computer code that a software or an app is written in. See, you can do it. You can explain things in ways that are understandable. And you got to show that code because it's the core evidence. Now, nobody understands the code. So what you do is you flash the code up briefly, and your expert explains very briefly what the code does and how the expert looked at it, and you move on. But you got to show the code because that's the evidence of what the software does. We had the other side. They didn't show the code. Their expert didn't even, he might have looked at the code, but he didn't talk about the code. And then in closing, they did say that don't worry about the fact that we didn't show you the code. It's just too complicated. You wouldn't understand it. Guess who was the foreman of that jury? A software programmer. A guy who wrote code, who did understand the code, and knew that when you didn't show him the code, it was probably because what you were saying was bullshit. Guess whose side won? We won. That jury deliberated for less than an hour after I think a 2-week trial. Less than an hour. I thought the jury was going to be out for a day and a half. They were out for an hour or less with us. And afterwards, that particular judge was interviewed and totally unrelated to the case, and referenced, without saying names or anything, he referenced that case and said, you can't talk down to your jury. I saw this recently where they thought that they could just talk down to the jury by not showing them the code and just telling them it would be over their head and too complicated, and it offended the jury and they hated them. And that's exactly part of what's happening here. You got to be relatable to these folks.
A table telling how each website was accessed, whether someone typed in a search for it or clicked a link.
Correct.
And you mentioned a couple different ways: typed, linked, generated. So typed would just be someone typing in the search bar something to search?
Yeah, so typed could be a few different things. So typed would be somebody typed in an exact phrase or word. It also could flag the typed version, a typed flag if you copied and pasted something into the URL address bar.
So if you're looking at a recipe for, say, cookies, and you copied cookies and pasted it into the search bar, would that be considered a typed event?
Yes, correct.
Or if you just typed cookies, that would be a typed event.
Or cookies, or if you typed in, say you put CO for cookies, and then Chrome tried to auto-populate what they think you want to type, that would also create a typed event as well.
And then you mentioned linked. What is a link to access?
Link would be that you clicked on a hyperlink, which brought you to a different page.
And what is a hyperlink?
That would be it's a word phrasing, and then behind the word phrasing, there is a website coded behind that.
Is that like when you go?
And remember, the whole point of this guy is he's the computer expert that they've called to say Lindsay Clancy was looking at websites about self-ending oneself months before the bad thing that happened in the case. And we're several minutes into this guy's direct examination, and they have not said at any point what this guy is here to talk about. Now, we know, because I've told you, I know because I watched it before, but this jury at this point has no clue what this guy is here to talk about or why he's relevant, why they're having to endure all these nonsense technical words. Nonsense from their perspective. A lengthy overword explanation for what a URL is.
On a website, and there are certain words
isn't
that are underlined that
1995.
you can click
We all
on
know
and
what a
it will take you
URL
to
is.
another page.
Yes, correct.
What about generated?
Generated is something that Google would suggest, Chrome would suggest.
Now, what is the Wayback Machine?
The Wayback Machine is a
Absolutely.
website
Jury is nodding off.
that
Absolutely.
is I don't say monitored. It's created and maintained by the Internet Archive as a company. It's a 501(c) nonprofit. And what that does is it goes out on the internet. It takes snapshots of the internet, web pages all over the entire internet, and then archives that. So you can go back in later. It started like in the mid 90s or so, but you can go back to pick a date, pick a year, and you can see what that website looked like at that time, or approximate. It doesn't copy minute for minute, day for day, but you'll get something around the time that you were looking for of what a particular page looked like at that date and time you want to see.
So with regard to this case and looking into how that site, Suicide Methods, was accessed, what did you learn? Or what did you see?
When I went back?
Yeah, so go ahead.
So I saw, the first thing I saw was a Facebook visit at 9:40 that morning.
9:40 a.m. on August 23rd, 2022.
Correct.
And what was the Facebook?
The link was lynn.say. I believe it was 968.
So Lindsay with a dot in between the D and the S, 969.
969, correct.
And after the visit to the
Okay, so someone, let's assume that Facebook name was Lindsay's Facebook. What does that mean? Does that mean Lindsay was looking at her own Facebook page? Or does it mean someone else was looking at her Facebook page? And this guy, I think, doesn't know that.
the Lindsay.969
Or at least doesn't know the difference.
Facebook page, what happened next?
There was a search in
Check the barbecue
Spotify
real quick.
music for the singer Tom Hall.
What time was that at?
It was shortly after.
Is your memory exhausted?
Yes.
Do you have your report with
I do.
you? With permission?
He should have already had his expert report with him. They should have handed it to him at the beginning of his direct examination.
That was at 9:42.
Let me explain what that is to folks who
So-
are not as familiar. When you have an expert in a case, because that expert is going to be offering opinions that aren't just based on, just his perceptions of things, experts have to issue a report. That report has to contain essentially what are the opinions they're going to offer at trial, and what are the bases for those opinions. And it's a written report, and you exchange them months before the trial happens. So he had a report, and best practice here for trial is you always give the expert this stuff when they sit down so that they've got it there in case they need it, instead of having to interrupt the flow of the examination like she's doing now.
Approximately 2 minutes after the Facebook account was accessed?
Correct.
And that website, was that a Wikipedia page?
No, that was Spotify.
Oh, I'm sorry,
Music.
Spotify music. And then what did you see next?
There was a song off of that search in Spotify.
Was that That's How I Got to Memphis song?
Yes.
And was that at 9:44 and 18 seconds a.m.?
Yes.
Then what happened next?
There was a Google search for Tom Hall.
And was that at 9:44 and 30 seconds a.m.?
Yes.
Okay, so on this device, the first thing that happens is Lindsay's Facebook page is looked at. Then there's a song, and I don't know who the author of that song is. I'm assuming it's this Tom Hall guy. And then there's a Google search for Tom Hall. And remember, Patrick has already said he's the one that was looking for Tom Hall. Why the prosecution is going back down this road, I don't know. But let's see if they get somewhere that's actually useful for them.
And what did you learn from that Google search?
Off of that Google search, there was the Wikipedia page for Tom Hall was visited.
And were you able to use the Wayback website to see what that
100%.
Tom Hall page on Wikipedia looked?
100% from Steph Bowen. I'm not a lawyer, but I was a juror just a few weeks ago. And what ticked us off the most was lawyers and witnesses who wasted our time. Yes, 100%. You have to be mindful of never wasting the jury's time. And that's a huge problem that this prosecution has. It's frankly, as a civil lawyer, I will say, I think it's a problem with criminal cases in general. Now, criminal law, criminal cases, you've got a lot of constitutional protections in there. Because of those constitutional protections, courts do not put time limits on the trial. That's why criminal trials go for a long time. Like the O.J. Simpson trial was like 6 months. There's been other ones recently that have gone for like over a year. That's because constitutional rights. Civil cases, you don't have that. And so in civil cases, a judge gives you a chess clock. Each side gets 6 hours to present their witnesses and do their cross-examinations. And that's it. And if you run out of time, you run out of time. That's all you get to do. So usually it's not 6 hours. Usually it's like for like a week-long case, it's like 10 to 12 hours aside, maybe 9. But it forces you to be efficient and forces you to not waste the jury's time because you literally can't. Here with this criminal case, there's no guardrails on it. And so I think that's a huge problem this prosecution's had throughout this trial is they're just not efficient. And it does piss the jury off. Jurors really get pissed off having their lives disrupted to begin with. And you need to show that you respect what they're doing, not through your words, but by your actions, by being efficient in how you conduct a trial. I have also been a juror twice, ironically, twice since I became a lawyer. And so I understand exactly what Steph Bowen was saying here.
Looked like around the time of August 23rd, 2022.
I did.
Is this a copy of that Wikipedia page from the Wayback Machine?
Yes.
You can have this marked as the next exhibit.
No objection.
All right.
I have no objection to any of the documents.
This is Tom T. Hall.
Tom Hall, yes.
So contrast the defense counsel with the prosecutor. Remember the prosecutor, when the defense attorney wanted to use a document, the prosecuting attorney flip several minutes. The defense attorney's like, I don't have an objection and I'm not going to object to any of her exhibits. There's two reasons why he does that. First, it goes back to that respecting the jury's time. He's making a point to say, I'm not going to waste your time looking through this stuff. Second off, he's got a plan. He knows where he's going to go with this witness and with this case, and he doesn't care about any of this. And because he doesn't care about any of this, he doesn't care what's in her stupid exhibit. I'm not saying the exhibit's stupid, but from his perspective, he doesn't care about this exhibit. It's stupid. It doesn't matter. It's irrelevant. He's got his own plan. So he's not going to, you don't fight the things that don't need fighting. You don't sweat the small stuff. And we haven't seen it yet, but we will see it in a little bit. Like, he doesn't object to things that are plainly objectionable, like questions the prosecutors asked that he could object to, that he doesn't, because he just doesn't care, because it just doesn't matter to him. And you don't waste the jury's time with pointless objections.
All right, that may be. Thank you.
Could you see what happened next once the Wikipedia page for Tom Hall was visited?
So I saw there was an anchor on the URL to the death section.
What does that mean, an anchor to the death section?
So an anchor would be put at the end of a URL, so a web address.
And remember, Patrick Clancy's already said he's the one doing all this. So they're going through this really laborious, painful drill over searches and things where the prosecution's own witness, Patrick Clancy, said he was the one looking at this stuff.
So what an anchor does, it's a pound followed by a section of that page. So if you think of it as, say you go on your banking website and it lists like a table of contents and it has login, mortgages, rates. If you click on, let's say, rates, it's going to jump all the way down to that page, just to that section. So it's a table of contents that's going to direct you directly to a certain section of the web page.
And so on the Wikipedia, someone clicked on death and it brought them down to that portion?
Correct.
And in the death section, could you tell what happened once the person was in that area of the web page?
Yes.
What happened there?
So in the description that the Wikipedia page described of Tom Hall's death, there was some wording regarding a shooting related to his ultimate suicide. Go ahead.
Showing you what's been marked as 232. This portion here under death where it's self-inflicted gunshot wound to the head.
This is all about the Patrick Clancy stuff.
Yes, correct.
And that portion there with the underlining, is that what you were describing earlier as a hyperlink that you can click and it takes you somewhere else?
Yeah, so inside that phrasing, there's actually a URL behind that with an anchor as well.
Now, something like that type of hyperlink, can you hover over that with the arrow that the mouse directs, hover over that and automatically be taken to that site? Or do you actually have to click on that link?
No, you would have to click on that phrase with the link behind it.
And so,
Oh boy.
based on your examination,
They're now getting into
of
how
the
you click on a link to go to a
Service
web
Pro in
page.
that area, was the hyperlink clicked on?
Yes.
And where did the hyperlink bring the person?
We
Are we right back?
now got to the original
I just
artifact I
realized
had
I didn't have
located,
my
which was
handy
the
thermometer.
Wikipedia suicide method, but it directed it directly to the shooting section of that page.
Could you tell how long the person spent on that page, the suicide methods page, or how long it was accessed?
No.
Could you tell what time it was accessed?
I mean,
Yes.
I need to get
What
my
time was that?
handy dandy thing.
I don't recall the specific time.
Want to look at your report?
At 9:45 a.m.
So 9:45 a.m. The suicide methods page was accessed. Is that
Correct.
And did you use the Wayback
My
Machine to
ThermaPen
see
1.
what it would look like on August 23rd, 2023?
I did.
Is this a copy of what you produced?
All right, just because Symphonia.
Yes.
You can have this mark as an
that-
exhibit.
That may be admitted.
I can hear the jury snoring. Yeah. Okay. While we wait for this painful direct examination to continue, I'm just going to check my fire.
Thank you.
And what could you see happening when from that page?
I observed after that another Wikipedia page that went to the Grafton Bridge.
And was that from a hyperlink within the suicide methods page?
Yes.
Showing you page 8 of exhibit 233. So within this jumping section is where there was the hyperlink to that bridge
Correct.
here,
Yes.
Grafton Bridge. So again, the person had to click on that hyperlink to access Grafton Bridge.
Yes, that would be correct.
Now, you said that the suicide methods page was accessed at 9:45 a.m. What time was the Grafton Bridge web page accessed?
That was shortly after that.
Do you want to look at your report?
Could you imagine being a jury having to listen through this?
At 9:48.
9:48?
Correct.
And so approximately 3 minutes after first accessing the suicide methods page, the hyperlink for the Grafton Bridge is clicked.
Correct.
Was there any other activity besides going to the suicide methods page and then the Grafton Bridge page? Any other activity that you saw within those 3 minutes?
I do not know.
And so did you do the Wayback Machine again for the Grafton Bridge?
I did.
This is a fair and accurate copy of that page.
Yes.
Theo, I don't think prosecutors are assigned cases randomly.
be
This was
admitted.
obviously a case brought by the district attorney, so whoever is the elected DA for that county. And then how they assign it out is up to the district attorney.
You're not able to tell who's actually at the computer doing all of this, correct?
No.
You can only see what data there is and what's been accessed, correct?
Correct.
Thank you.
Okay, two things. Hold on. Let me. Was that her last question?
All right, Mr. Reddington.
Wow.
That's it.
Wow. Okay. First rule of cross-examination or direct examination, you need to end with a good point. So her final question to him was, after making us sit through all this, and by the way, you don't know who is actually on the computer, right? No, I don't know who is actually on the computer. That's terrible. Second off, it's a leading question. So this was like a good example. A leading question is where you basically give the answer and say correct, where all the person has to do is agree with you to basically give the answer. It was raining yesterday, correct? It was hot yesterday, right? Those are closed or leading questions. You can't lead on direct. And in this trial, this is the worst case I've ever seen of any trial. And I've been in a lot of trials and I watch a lot of trials of people asking leading questions of their own witness. And the defense attorney doesn't say anything. He could have objected, but he doesn't, because for two reasons. First off, objections should be tactical. You don't make an objection just because you can, even if you're right. You only make them tactically when you need to. And second off, the answer helped him. The answer proves that, okay, you just made us all listen to this crap for half an hour or whatever. And so your conclusion is that you still have no idea who was on the damn computer. That's the whole fight. That's the whole fight on this issue, is who's actually on it. Was Patrick using it or was Lindsay using it? Now we're going to watch the cross, but I think we've got a couple new super chats in here. So let me just get us caught up. So we've got Peanut 5084, 440 joules, Unk Alert, thanks. And then Tyrannosaurus Rick for $10. Love your content. And Bling Gonti $2. DA should copy paste examine from Adelson trials. Yeah, I did watch a lot of the Adelson trials. I thought that the prosecutors in the Adelson case were pretty good. I thought that the prosecutors in if you watch the New Mexico movie case, the one with Alec Baldwin, not the actual Alec Baldwin case, but the one with the armor before then, I thought the prosecutor did a pretty good job on that one. The prosecutors here are I think they're young. I think they're not experienced at trial work, because it's just the choices they're making throughout are bonkers. And then Rampalax 6048 100 joules, Marshmallow High. Thanks so much. All right, let's see how Reddington addresses this. And this is where we're getting into like why I really liked this as an example, because I with all the stuff going on with all the other cases, we just didn't have time to do like daily updates of this case. And what I did want to cover was just how great I think Reddington is as a trial attorney. So let's see how he kind of dismantles this.
That's why you're here today, to talk about a search.
Back up.
Thank you. What data
Listen to how he
is
starts
and what's
off.
been accessed, correct?
Correct.
Listen to how he starts off. And remember, the jury has just sit and listen to 30 minutes of nonsense, which was ended with, you don't know who was actually using this thing? No, I don't. And listen to how Reddington handles that.
Thank you.
All right, Mr. Reddington.
That's it? That's your testimony? That's why you're here today, to talk about a search that was involving Tim Hall?
Sustained, if you could.
So I apologize. Your testimony today is based on that search on August 23rd, right?
Correct.
Of 22, right?
So the judge sustained an objection because it was a little argumentative. That this is what you're here for? This is the whole point of this? That's all it was? This stupid search again? He knew what he was doing. He knew that it would get objected to. It didn't matter because the jury heard the point, and the jury was probably feeling the same way. And now the defense attorney just gave voice to what the jury was probably feeling. And that's why he did it. All of this is theatrics, remember. And so he did it specifically because he knew he was irritated, and he knew the jury was probably irritated. So he's going to make a comment and point out, like, what a waste of our time.
And you were working as a state police officer back then, right?
Yes, sir.
And were you attached to the Plymouth County DA's office, or were you working somewhere else?
I was assigned to the cybercrime unit.
And the cybercrime unit works with the DA's office in Plymouth?
The cybercrime unit's its own independent statewide unit.
So in the sense that you're independent, it's still the district attorney
This is 100%.
and his assistant DAs that would
100%.
reach out to the cybercrime unit and ask for help, right?
Or it could be the troopers assigned to the State Police Detective Unit.
Joshua McGillen. He was the lead investigator on this case, right?
I assume so.
Okay. So you were tasked
So one question here, one point.
to analyze the computer to surface.
From Tingled Charlotte, the prosecutors are both very experienced. I forgot the exact years they each have. Now, it's different with criminal than civil, but just because you've got prosecutors that have been attorneys for a long time doesn't mean that they're experienced with trial work. And again, I don't know how it is in a district attorney's office. You get a lot more trial work there, but I think you start off doing things like DUIs where you're not really doing a lot of trials. You got to be an attorney for a while before you start doing actual trials. And even then, you're not the person who is going to be making the calls about how the strategy plays out. There's going to be a more senior attorney there doing that. So when I say inexperienced, I'm not saying I think that these are those attorneys' very first trial. I'm wondering if it's their first trial as lead counsel, because the choices that are being made, like from the people in the first chair that are the ones deciding, here's how we're going to approach, like, here's the witnesses we're going to call, here's our strategy for these witnesses. That's what I say is bonkers, because it's not efficient at all.
Surface Pro computer, right?
Yes, correct.
And computer. So you were tasked to analyze the computer, the Surface Pro computer, right?
Yes, correct.
And by all accounts, that was owned by Pat Clancy. Is that correct?
That is correct.
And it was located in his office, right?
Point one, it's Patrick Clancy's device.
I don't know where it was located.
Okay.
And now he makes a point, it was in his office, right? Well, the guy didn't know, but it didn't matter because the attorney just said it. And the prosecutors probably should have objected. And the objection would have been like, facts not in evidence or calls for speculation or something like that. But he just said it. And now the jury believes that that was probably what the truth is, even though the witness actually doesn't know.
It's fair to say that when you analyzed the computer back in October of 2025, it was an investigatory role that you were using to locate potential evidence, right?
Correct.
And what is it you were looking for?
I was provided a search warrant with search terms, and that's as far as I knew of the case.
And what were the search terms?
I don't recall specifically, but they were spelled out in the search warrant.
So when you have search terms, you take a person's computer, and then what do? You access it through a device?
So I was provided the images. I never saw the physical computer.
So when you got the images, you were able to load them up onto your computer?
Now, to people versed in software, that sounds reasonable, right? He was provided the software image, and he was analyzing that. That's how the forensics happens. But here's the subtle thing that the defense attorney is doing. He's implanting the seeds of doubt in the jury's mind. This guy he hasn't even seen the device. He doesn't know anything about the case. He was just given some search words. And so he just took those terms and ran them and saw what popped up. He doesn't know the facts. He doesn't know the context. He doesn't know who was actually doing on the computer. He doesn't know where the computer was. So he's dismantling the credibility of this witness as someone who just doesn't know. He's irrelevant because he just doesn't know anything about the important facts.
Computer, I imagine?
Yes, we'll use a tool to help parse through that data. Correct.
And then as a result of that, you were able to plug in words that you could search for, right?
Yes.
For example, like suicide?
Suicide would be one.
Drugs?
I mean, I don't think that pertained in this case, but you could search.
It did.
I don't recall the specific.
Yeah, there's one other point here. They used the self-ending word. She's not on trial for self-ending. She's on trial for what happened with the children. And there's a little bit of a logical disconnect, at least just within the four corners of this witness, why even doing a keyword search for suicide is even relevant or important.
Terms in the
Okay.
search warrant.
Okay. So after you did your search for whatever it is that you were looking for, suicide and other, you're unable to tell us what else you look for, but in any event, you came across this entry on August 23rd, and you indicated that the time frame that you're dealing with on that computer, the Surface Pro computer, was 9:40 in the morning. Is that right?
Keep that time 9:40 in the morning. Keep that in your heads. That actually is really important to this cross.
Can you rephrase that?
Yeah. You can look at your report too. I mean, if you have documents in front of you, do you have?
I do.
All right, so you can take a look at it. You have a document that's captioned matching results. Is that right?
I do not have that in front of me, but yes.
And would that be the search that you conducted?
Is that the magnet tool report?
I don't know what it is. And I apologize. I had surgery and I forgot to say so. What is that?
This is the main page of the forensic tool.
Okay. And looking at the main page of the forensic tool.
He's got his magnifying glass. I love that.
It's August 23rd.
Symphonia needs that magnifying glass to see my face.
This also doesn't. Which, we're talking about this highlight here?
Yeah, but what does that indicate?
That's an inbox. That's not that.
All right, so what time?
Cooper, could you keep your voice up
Sorry.
or make sure you speak to that microphone?
So that highlight is a bail inbox.
Okay. And that would be the HTTPS. And then underneath that, it makes reference to at some point that you were able to see that Lindsay or Lynn's Facebook account was accessed. And it wasn't even the account, it was actually the homepage, right?
Correct. It navigated to the Facebook person's account.
Okay. So that would tell us that that particular Facebook account was accessed, and then that conducted the search that you just testified to. That's the next thing.
This here does not have Facebook, does it?
All right. How about this next one? Does that have the Facebook visit?
This one does, yes, correct.
Okay. Take a look.
Both of us.
Yeah, both of us. Blind.
Yes, that'd be right here.
All right. Thank you. Now, just before I leave, above that, does that also indicate like these two top lines?
That was a CNBC web visit, which was typed in. And then there's access to a Google Gmail account.
And whose
Inbox.
Google Gmail account was that?
That I don't know.
Because those two lines and references to the Google account were not in your report, right? You started off with the Facebook search, if you will.
Yes.
So you started off with Lindsay Facebook that was signed into the homepage on Patrick Clancy's Surface Pro computer, right?
So my tool report has all of the artifacts tagged as evidence.
Okay.
Let me pause here. So here's what the defense attorney is doing, and why I really like this. So we've already laid out, this is Patrick Clancy's, not Lindsay's device. And the whole thing that they started off in direct was there was this Facebook, and it was Lindsay's Facebook page that was looked at. And what the defense attorney says, well, okay, so you started your analysis on, let's say, line 5 of this, which was Lindsay's Facebook. But if we go up to line 3, in terms of the order of the search history or the Google Chrome history, item 3 right before that was a Gmail account, and you didn't look and investigate who owns that Gmail account, and you didn't look at that. He doesn't say it here, but the inference he's laying out is it was probably Patrick Clancy's email account, or maybe the attorney knows, and he's just he's just kind of dropping the seats.
So when you tag the actual data from the Surface Pro and the HP laptop as well, right?
Yes, correct.
And your October report back in was it 25 or was it 22?
25.
So, but nothing changes on the computers. I mean, whatever your searches are and your records don't change over the years, right?
No, as long as it's preserved in that state, and the images of that computer will remain the same.
Okay, so, and it's fair to say that with this investigation, obviously happening back in 2022, that the computers were hermetically sealed and stuck somewhere with an evidence locker to make sure that they're preserved, right?
Yes, that would be best practice.
Okay.
That would be correct.
So then in October of 25, the district attorney's office asked you to conduct a search of the computer, apparently. Is that right?
The trooper in the Plymouth State Police Detective Unit reached out.
And that would be McElligan, right?
No, it was not.
Okay, do you know who it was?
Trooper Justin Paul.
Justin Paul.
Correct.
Okay. And as a result of that, you then prepared your report. And one of the things that you did is you noted that on August 23rd of 2022, at 9:40 and 08 seconds, that there was an access to the Lindsay Facebook account, right?
Oh, there was a visit to that page, correct.
Right. And then that page continued on to look for Tom Hall and walking to Memphis or whatever.
So someone picks up the device, and I think this is a tablet. I don't think this is a computer. Someone picks up the tablet, the Surface Pro, and the first thing is a Gmail account, and then there's a Facebook account, and then it moves on into looking up Tom Hall stuff at 9:40 a.m. Remember, keep that time in mind, because that is really important.
And the songs, right?
And I'll say, so we know when we get to the Tom Hall, the jury knows that Patrick Clancy was the one looking for Tom Hall. So they know that. So, and this jury, or this attorney, he's leading, he's revealing the story like layers of an onion, a little bit at a time. And that's why I just think this is just a wonderful
Yes.
cross-examination.
On Spotify?
Yeah, yes, after that was a Spotify.
And then the time frame of that would be that you went to a hyperlink that took him to methods of suicide. Is that correct?
That is correct.
Now, were there any searches on that computer for example, ways to kill?
No, there was not.
To your knowledge, and I understand that you might be stuck with what you investigated, but are you aware that there were any searches from Lindsay Clancy or Patrick Clancy on ways to kill? You ever heard that?
In my initial report back in October, that contains all of the evidence artifacts that I had tagged as evidence and provided, I did not come across that, no.
Right.
So this is an important point, because somebody who might, let's take the prosecution's theory that she was looking at this information as part of premeditation leading into what happened with the children. But here's the problem that the defense attorney is highlighting. Looking up self-ending is not the same thing as looking up ending others' lives. Those are two different things. Just because there is so much mental illness and health issues tied up in this. So I'm trying to keep things simple and straightforward in terms of how I'm analyzing it. So if I'm using ineloquent or if I'm using ineloquent language, I'm not trying to be insensitive. But the fact that someone might be looking up the one, what relevance does that to what she's actually charged with. Looking up self-ending yourself. And again, this is day 13. The jury's gone through almost 2 weeks of hearing from doctors about a number of prescriptions she was prescribed, all of her mental health issues, the depression, hearing of voices, all of this stuff. They know very well that this is a woman who is not well. Looking up the one of doing that to yourself, how is that premeditation of doing the other? It's not, I understand the argument, but it's not strong. It's very tenuous. And that is what the defense attorney is highlighting. Okay, so even if you saw stuff about self-ending, you didn't see anything about how to take another person's life. No, I didn't say anything like that. That's, he's doing a good job of highlighting the problem.
So basically what you are leaving with the jury would be that.
And I'll add one thing. This is what we call turning the other side's witness into your witness. He's now getting this guy to admit to all the things that support their side of the case, that she wasn't planning this. She wasn't planning on doing it. There was no premeditation. He's now testifying for the defense effectively.
On that date of August 23rd at approximately 9:40 in the morning, and then carrying forward with jumping from Tom Hall to the Wikipedia account to the underlined name, suicide, jumping to that page, that all occurred between 9:40 and say 10 o'clock in the morning, right?
Correct.
Again, so all these searches, all of this that this guy is here, that the prosecution is using this guy to try to say it was Lindsay Clancy doing this stuff, looking because it was her Facebook page that was looked at, and it couldn't possibly be the husband looking at his wife's Facebook page, but whatever, it's got to be her according to the prosecution. And all of this happened between 9:40 and 10 o'clock, and he's now repeated this a few times. He's cementing, because he can't just do what I'm doing to you all and say, pay attention to 9:40. He can't turn to the jury and say, hey, jurors, pay attention to 9:40. So he's reinforcing this, and he's committing the witness to a timeline. All of this was between 9:40 and 10 o'clock, right? Yes. And now watch, I don't know if it's the next thing he does, but watch him destroy the timeline.
Did you know, sir, that on August 23rd, prior to your report indicating the Facebook account, that Mr. Clancy signed in, and it was Mr. Clancy's email that accessed the Facebook account for Lindsay Clancy?
I did not.
Okay, so he set it all up. He set up and established for the jury what the house of cards is. There's this Gmail, and now he's going to start dismantling. And so a lot of this is subject to objections that the prosecuting attorney should probably be making. As facts not in evidence, or speculation, or outside the scope of his report or something. First question, did you know that it was Patrick Clancy's email address that was looked right there before the Facebook page? No, I didn't know that. Oh, and by the way, he'll probably have his own. It has to become evidence. The fact that he said so, and the guy said, I don't know one way or the other, that doesn't make it evidence. But he's saying this because he's probably got an expert lined up himself who is going to go through all of this. And what that expert says will be the evidence that is admissible. I understand the distinction is very odd. And there's a great line in one of my favorite movies, 12 Angry Men, when the attorney gets up and says something kind of like one of these speaking objections, like this guy said earlier, that's stuff that or when he walked up and said, that's all we're here for. And the judge sustained it. And the defendant turns to his lawyer who just did this and just got sustained. He's like, well, what does that mean he got sustained? Well, it can't be considered as evidence. Well, how is the jury supposed to unlearn what it just heard? Bingo. Same thing here. It's not technically evidence because the attorney said it and not the witness, but the jury, how does the jury unhear that? They don't. It's very masterful theatrics. And he will follow up down the road with an expert who will say the thing, and that can then become the evidence. But he's saying it now to dismantle this witness on cross in
And
terms
that
of
was not
credibility.
included in your report, was it?
No, it was not.
And you know that the Clancys had 3 children, right?
I did not.
Well, you know that you were working on a case where Lindsay Clancy was the mother, and she was married to Patrick Clancy, right?
Correct.
And did you know, sir, that on August 23rd of 2022, that 2-year-old child was brought by Lindsay to South Shore Health for Dawson's ear recheck, that he had
Let
problems
me
with
back up real quick.
by Lindsay at 3rd of 2020.
Correct.
And did you know, sir, that
Okay. Here's the big one.
on August 23rd of 2022, that 2-year-old child was brought by Lindsay to South Shore Health for Dawson's ear recheck, that he had problems with congestion, but no complaints of ear pain, no fever. And that was on August 23rd, 2022, that he was examined at 10:15 in the morning.
I'm not.
So he established the timeline. All these searches were 9:45 until 10 a.m. But at 10:15 in the morning, where was Lindsay Clancy? She was in the doctor's office having her kid treated for an ear infection. So was she the one using the Surface tablet at 9:40 in the morning? It seems real unlikely.
Privy to those facts.
So you don't know that Patrick Clancy's email signed into Lindsay Clancy's Facebook account. You're not aware of that, right?
It's whatever the default profile was signed into the Chrome browser.
And then
That is not a good admission for the prosecutor. This witness is really now just helping the defense. The access of that Facebook was just the default profile. So what if Patrick doesn't use Facebook, but Lindsay does? And so Lindsay's profile comes up by default. That happens. I use Facebook. My wife doesn't. We don't have the same devices. But if we had only one device, then it would be my Facebook page that came up and not hers. Just like when they go to YouTube, my kids open up YouTube on our Apple TV, and it's my account. Now my account is filled with my daughter's million channels of her wanting to put on makeup and beauty care products. It's hilarious, but I get all sorts of random things. Or like, we've got a new puppy, and when we need the puppy to take a nap, we'll put on one of those puppy sleep things. And so now my YouTube page is filled with all that because everyone's using my Facebook account. Well, so Patrick Clancy is using, this is the defense's theory. Patrick Clancy is the one, he picks up the device. It opens up by default to Facebook. And because she's the one that's got the Facebook account, it opened up to her account. It doesn't mean that it was her, because where was she? Well, we don't know yet where she was at 9:40 a.m., but we know that at 10:15, she was physically in the doctor's office with her kid. So what are you doing for the 35 minutes leading up to that? Are you sitting around on your tablet looking up ways to end yourself?
that accessed the Facebook account, which looked up Tom Hall, the singer, right?
Yes, correct.
That then led to the Wikipedia talking about suicide.
That is
right?
correct.
Led to the Spotify talking about somewhere in Memphis, whatever the song was, right?
Yes.
And this was all occurring from 9:40 in the morning until, like I said, 10 o'clock thereabouts, right?
Correct.
You tag.
So just right now, the prosecution's theory when it comes to these searches is just completely dismantled. This is why, another reason why I think these prosecutors are not experienced in terms of like being lead counsel, and if they are experienced, all the worse for them. You have to apply a healthy amount of skepticism to your own facts. You can't take a simple fact that looks good on the surface for you and just run with it. You have to scrutinize your own evidence, because think about your timeline. And you know that she was at the doctor's office 15 minutes between 15 to 30 minutes after these searches were done. Do you really think that it was her looking at these things, or was it someone else? They didn't scrutinize their own facts. They just ran with this theory. They made it part of the trial, and it's blowing up in their face. And when the jury will be instructed that when you don't believe a witness for one thing, you don't have to believe the witness for anything. So all this stuff, all this credibility has really impacted. I mean, not this guy like personally, like is he bad at his job, but it just is like the credibility of what he's saying, the usefulness of what he's saying. The jury can just completely disregard this. And once one side starts to lose that credibility, the jury just tends to roll them. And that's the problem these prosecutors have. They've tried to combat that with questionable choices, in my mind, of how much they're leaning into the horrific nature of what happened to the children. And I'm not going into that. There is some really good cross-examination of the psychiatrist and some of these other people that I just don't want to get into, because it's gruesome, it's horrific. And this, for me, was I think a better example of what I wanted to talk about. But they're trying to combat all foibles like this of their theories just blowing up like landmines in their face with just ignore that. It's kind of like the Wizard of Oz. Pay no attention to the man behind the curtain kind of thing. Just pay attention to the horrific nature of this. That the horrific nature of what happened is not in dispute. She has stipulated in open court that she did what she did. She has stipulated that. That is a judicial fact. It is not subject to dispute within the four corners of this trial. She admits that she did the thing. The fight is over the why. It's about whether she was under a psychotic break at the time and couldn't control her actions. That is really what the fight is about. And the prosecution is trying to get the jury to ignore that by just getting them to stay focused on the horrific nature. So it's been witness after witness after witness. I had this video I had teed up on, I think, the third day of trial. They called 9 police officers and first responders, all to just say the different version of the same, like 30 minutes of what happened when they showed up to the house, which room they went in, and just over and over and over about the children, what happened to them. And obviously that's horrific and it's awful. But they're leaning so heavily into that because the rest of their case is problems like this, these landmines all over the place.
Actual data from the Surface Pro as well as the HP laptop, right?
I did.
And your October report contained searches from the Surface Pro, right?
Yes.
And you recall, for example, just a representative sample that, and this would be on the Surface Pro computer. Now we're jumping ahead to December 5, not August of 22, December of 22. One of the inquiries of the Google searches was what to do when a psychiatrist overprescribed, right?
Yes.
Searches for medications, right?
Yes.
Including Lamictal, right?
Correct.
Can bipolar disorder be temporary, right?
Yes.
Can benzos reveal bipolar disorder, right?
Yes.
How long are detox programs, right?
Yes.
What is DBT? I'm just saying that's a search. I don't know.
Oh, yeah. I had to look that one up too.
Okay. Lamictal versus Zola, it says Zolafine.
So what he's doing here, this is part of the defense's theory. They're just highlighting all the other relevant searches about her mental illness, the medicine she's on, the prescriptions that she'd been given, all of that stuff, because their theory is literally she was so over medicated with all these really powerful antipsychotics and antidepressants and all these things that it caused her mental illness to get worse and led to this psychotic break that led to what happened. And that's their whole theory. And so again, he's converted this witness. This is not a good witness for the prosecution anymore. This is a fantastic witness for the defense. And he's not, yeah, oh yeah, those are all searches that they were doing. And it all fits in line with the defense's theme and theory of the case.
But I would suggest it would be Zoloft. That was a search, right?
Yes, correct.
What is mania? Was a search, right?
Yes.
Ketamine for benzo withdrawal. January 18th of 2023 was a search, right?
Yes.
Ketamine therapy on January 18th of 2023, correct?
Yes.
Now, you know, maybe not personally, but you know Steve Verino, who's also a gentleman who does what you do with computers and laptops and stuff, right?
Yes.
Now, you've worked on cases, and you know Steve, you recognize him right here, right?
Yes.
Now, where he's going here is a little bit different. Now he's just going to straight up
and Lindsay on
annihilate this guy's
accessing
credibility.
information from cell phones and computers, and he actually,
So let me
through me, reached out
tee this
about
up a little bit.
a month ago to the DA's office.
When you have a trial, each side has experts. So here, this guy is saying with these searches and what happened, and the defense is going to have an expert too, who's probably going to get up there and say, yeah, it was all Patrick Clancy's stuff. And by the way, there were errors in this guy, Kyle. I can't pronounce his last name, so to avoid getting flamed in the comments, I'm just going to say expert Kyle. The defense expert's going to blow up expert Kyle's analysis and say, oh, he's got all these errors. And this is what Reddington is now. He's gotten all the good stuff he needs, and he's kind of done with this witness. So now he's just going to end with dismantling this guy's credibility by pointing out a bunch of analytical errors.
Office and raise some questions, correct?
I'm not privy to that.
Oh, well, the DA reached out to you about a month ago and asked you to revisit your investigation. And as a result of that, you created another report, didn't you?
I did.
So he's now laid out, some of which is the guy has agreed to, some of which he didn't know, but it doesn't matter. The jury heard it all. The defense's expert identified analytical errors. The defense went to the prosecution and said there are analytical errors in the guy's report. Prosecution went to expert Kyle. Expert Kyle changes his opinions and issues a new report. That's a problem. Anytime an expert is caught making errors and has to change their report, it just again, it's dismantling the guy's credibility.
And that would just be on July 26th of 26, right?
Yes.
And that was after DA reached out to you, but didn't tell you it was because we had questions that Mr. Verino asked me to find out about, right?
Yes, I was not privy to that.
So as a result of dealing with the DA in July 26th of 26, you then prepared your report, and the purpose of that report was to find out more details, if you could, pertaining to the, quote, methods of suicide page, right?
Correct.
And in your July 26th report, you then went into detail about your findings, correct?
Yes.
And we would agree that that particular webpage was not a search for methods of suicide. It was actually the Tom Hall and the music, right?
That is correct.
And then the URL.
It was not a Google search. Nobody was searching for it. It was someone clicked on it as a link to the Tom Hall page that Patrick said he was looking at.
Shows access to Lindsay's Facebook profile, correct? You accessed and found out that Lindsay's Facebook profile
was a web visit.
Right.
Yes, correct.
But you don't know that it was Lindsay that was actually using that computer to search for Tom Hall, right?
I don't know who was sitting behind that.
You don't know that Patrick Clancy plays the guitar, do you?
I do not.
You don't know that Patrick Clancy is a music aficionado, right?
I do not.
You don't know that Patrick Clancy enjoyed Tom Hall music, do you?
I do not know that.
And you certainly don't want to leave it with this jury that Lindsay was looking up ways to commit suicide in August of 22, do you?
All I'm presenting is the facts that were presented in front of me.
Boom. The witness is cooked. You can sit down. He's done. Dinner's ready. But bottom line, I mean, he's just completely, he extracted from this witness tons of useful stuff. And then it's like, okay, now it's time to establish all the things that you just don't know. the jury knew most of this stuff already. They knew about the guitar. They knew about being a music guy. They knew about the Tom Hall stuff. You didn't know this. You didn't know this. You didn't know this. You didn't know this. Boom, you're done. That's how you dismantle an expert.
And it was a couple more questions, sir. When a user logs into their own Facebook account, it doesn't populate or bring you directly to the actual profile page. It brings you to the home page, right? That shows your followers and things like that.
I think so. I don't have Facebook or social media, so
Okay.
maybe, I don't.
So he didn't even know that what was being looked at was the public-facing Facebook page of Lindsay Clancy, not the internal home page.
That's all I have for this gentleman, Your Honor.
All right.
Let's see what the prosecution tries to do to rehabilitate this. And you're going to see a few things here, but one thing that tends to happen when Reddington annihilates one of the prosecution witnesses on cross is the prosecutors then start cross-examining their own witness with tons of close-ended questions, leading questions, stuff like that. And you're going to see this.
I would ask if I could, Judge, the two documents that I think he agreed that was part of the search.
Sure, yeah.
So they're doing some kind of sidebar for some reason.
They're already in evidence.
For identity.
Okay. So she's going to get back up. And can she do anything to save this guy? Let's see.
Sir, just for clarification, before when I was doing direct, if at any point I said August 23rd, 2023, what you did when you did the Wayback Machine was searches for around the time period of August 22nd, 2022, correct?
Correct.
And anything that you looked at that day regarding the search for suicide methods or any of the other places that were visited were August 23rd, 2022, correct?
Correct, 2022.
And the visit to the Grafton Bridge Wikipedia page was at 9:48 a.m., correct? Not 10 a.m.?
So the search
That
was
visit
at
was at
9:48, not
correct.
10. Okay.
And
Okay.
defense counsel asked you about the defendant being at the doctor's at 10:15 a.m. Are you aware that it only takes 4 minutes to drive from her home at 47 Summer Street in Duxbury to the Kingston location of the pediatrics?
So here's a problem with what she just did. It kind of goes back to assumes facts, not in evidence. So she gets up there and says, well, don't you know it only takes this amount of time to get to the doctor's office? Well, we don't know that. How would he know that? How would any of us know that? Have we pulled up the maps? Have we done the drive? No. And they haven't presented a witness on that. She's trying to fix this, and she's doing it with a bunch of leading questions and with a bunch of facts, not evidence. Well, yeah, it only takes this amount of time. But the jury's already heard all of this. They've already heard what this guy had to say, that he didn't know. The jury's already heard all this stuff that basically confirms that it was Patrick on there. And she's trying to quibble over a few minutes here or there getting to the doctor's office. And it just doesn't fly for me.
I was not, and I also wasn't aware that they went to the doctors.
And you can't tell us who was behind the computer at different times, correct?
No,
You can't tell us whether people used the computer, then got up and let someone else use it, and then went back to using it, correct?
no, you cannot.
You can only show us the data that you observed that day, correct?
Temperature to meet
That
here.
is it. Yes.
Okay, thank you.
So what has been marked for P for identification, which would constitute the health information records from the South Shore Health pertinent to the child. you're aware, sir, that the records, or you're aware, sir, you're not aware that the child was brought to the doctors not at 10:15, but was brought to the doctors around 10 o'clock in the morning. You aware of
I'm
that?
not aware of any of that.
And did you know how old the child was?
Sir, my testimony is related to the.
So you don't? The
computer.
answer is
I
no?
do not. No.
Okay. So is it fair to say, sir, that, I mean, from your life experience, that when someone has to bring a child, a young baby, to a doctor, you got to get him dressed, you got to feed him, you got to get in the car, you got to drive? And that's the 4-minute ride as well, right?
I'm not privy to any of that information.
That question was not to him. The question was to a jury. So the prosecutor gets up there, well, you know, there's only a 4-minute drive. So maybe she could have just been using this thing. Maybe she and the husband were passing the device back and forth. And he gets up here. Reddington is like, well, you have kids. You know how it is to get kids in the ready in the morning? A young kid. It's not just like you get in the car and go in 4 minutes. You got to get the kid ready. They got to get dressed. You got to get dressed. They got to eat something. You got to get, I mean, this is a young kid, so you got to get the car seat situated. I don't know if they were running any errands after this, but at least for us, we had a bag that we had to make sure was packed if we were going to go to the doctor, and then maybe we were going to go to the store. You got to make sure you've got diapers. You got to make sure you've got all this other stuff. It's not just a matter of just getting there, and she's got all this free time. And so he's just pointing this out. The guy doesn't know, but the jury heard it. And that's what I think this is a good redirect.
Thank you.
Or I guess it's a
Anything
recross.
further?
No.
All right, thank you, sir. You can
So-
sit down.
So that was the Lindsay Clancy trial that I wanted to show. I'm going to continue to monitor it, but I thought that it was a really excellent example of some good lawyering on behalf of Reddington, because I think the systematic way in which he dismantled this witness, converted the witness into his own witness, and then shunted off his credibility, just labeling all the things you didn't know. This. I thought it was just an excellent piece of lawyering. So with the Lindsay Clancy case, I'm going to continue watching it. I am going to continue looking for opportunities to bring up interesting crossovers between the case. Oh, here's my dog. Here, Liberty. Come here, sweetheart. All right, here's Liberty. Hi, Liberty. Okay. So, how are you in here? What are you doing? Look at the camera. The camera's over here. So, someone will come along to get Liberty here in a second. But I'm going to continue looking for opportunities to do kind of parts of this trial that I think are interesting to the practice of law and to trial work, and share them. I don't think I've got the fortitude to stomach out the day by day recaps of this trial. Okay, gonna go find mommy. Don't chew that. Don't chew that. Hold on. Let's take her around. Come here, sweetie. I'll be right back, folks. Hold on.
Liberty, come.
Mrs. Barbecue Counselor is off screen calling Liberty away. No. So Liberty is how old? So she was born March 6th. So March, April, May, June, July. Yeah, so she's about 5 months. And she's a handful. She's a full breed Labrador Retriever, a mix of English and American Lab. English Labs are supposed to be a little more gentle than American Labs, but she's a handful. And sadly enough, she is not getting along as well with our two cats as I thought. We did a lot of research, and Labs were supposed to be a great breed for cats, and we've got 2 rescues that we have, and named Anna and Elsa, because one is kind of white and one was kind of reddish brown, and they're sisters, so they fit very well with Frozen. And we also got them when my daughter was super into Frozen. So she's a great dog, but she's just not getting along well with the cats. She wants to chase and play with the cats, and the cats just want to be left alone from this monster. And anyway, so to conclude the Lindsay Clancy stuff, we will continue to look for interesting parts of this trial that we can highlight. I just don't have it. I just don't have it in me to do the daily recaps. It's too rough a subject matter, and it's very hard as a parent of two kids myself to watch what's going on. This is not to take away anything from anyone struggling with mental health issues themselves. This is a horrific case. There's no good answer. There's no way to deliver justice to any of these people. Lindsay Clancy's choices are life in prison or life in a mental institute, as I understand the nature of her defense. So it's just not, there's no way to deliver justice to anyone. And it's a rough subject. So I will continue to looking for stuff to bring up. If I sounded a little, if I'm having a little levity here with this, please don't take that to mean that I don't think the subject matter is incredibly deep and serious. It's just, it's easier for me to talk about the trial mechanics of this than to wade into the details of what happened. So I want to now, we'll check on our super chats here, but I want to switch over to a little bit lighter fare before we end the show. Let's talk about Ethan Klein versus Frogan, but let me check. I think we might have a couple super chats, maybe just one. So from Tyrannosaurus Rick, can this woman possibly be made to feel worse than she already does, even if found guilty? No, I mean, I think she had a breakdown the other day in court. And I think on the first or second day of trial, I think Patrick Clancy had a breakdown. They had to take his cross-examination out of order. So like he did his direct, and then something happened. They broke, the cameras turned off. And then there was another witness without the cross. And then they came back to Patrick Clancy for cross later on. I suspect that was probably because he had a breakdown of some kind. And she's had breakdowns and they've had to pause. Like, yeah, I mean, I'm not diminishing in any way what happened to these children, but there are some real issues with the seriousness of the mental health crisis that this mother was going through and what happened. And I don't know how you, I don't know how you, they said in the opening, Reddington said in the opening, she was suicidal then, she's suicidal now. Even if she gets well and her mental state gets well, how do you, I don't know. Let's talk about something a little bit happier, in the sense of lighter. Let's talk about Ethan Klein versus Frogan. So let me first orient folks that are not paying attention to this case. One second here. Just getting my documents ready. So Ethan Klein is a content streamer. And by the way, as we get into Ethan Klein versus Frogan, and I will continue doing some content about Ethan Klein versus Denims and some of his other cases, I want to caveat all of this. There are passionate people on both sides of this. There are some that think Ethan Klein is totally in the right. There are some that think Frogan and the other defense in the other cases are totally in the right. I am looking at this from the perspective of a litigator and someone who specializes in intellectual property. And what I think, where the facts that I see them lead me as I understand the law and trying to apply the facts of the law. I am not saying who is a good person and who is a bad person. This is one group of streamers versus another group of streamers, and they don't like each other, and there's politics mixed in. I try to keep politics out of my channel. I do not want the interesting topics we talk about with government corruption, corporate corruption, trials, litigation, the law. I don't want that to be diminished or blurred or tarnished by strong political feelings. So this is not about politics. This is about where do we think the arguments are going to go. What is this case about? Ethan Klein makes content. I'm going to keep this as distilled as I can. Ethan Klein makes content. Ethan Klein posted some content on YouTube. Frogan, who does not like Ethan Klein, immediately did a watch party for Ethan Klein's content. And the argument is that she just simply like hit play, and there was some commentary, but not enough. And she was just rebroadcasting his content to get people to watch her channel instead of his. In other words, to divert the audience for the content to her so that she could get streaming revenue off of it. Her argument is that no, I am legitimately criticizing him. I do have some criticism in it, and that constitutes what is called fair use. And fair use is an exception to copyright infringement. Ethan Klein has sued Frogan for copyright infringement, saying there was no fair use. She did not respond to the complaint in time. They did some negotiations. Those fell through. She was sued, like, let's say last year in like June or July or August. I don't remember it was summer of last year. She never answered the complaint. You're supposed to get 3 weeks to answer the complaint. She asked for an extension, which is normal. She got an extension to October. October goes by, November, December, January, February, March, April. Finally in May, they say enough's enough. They ask the court clerk to enter what's called default. Default does not end the case, but default says they haven't answered the complaint. It's step one of a two-step process to end a case through the default process. First, the clerk of the court declares that they are in default. Second, the plaintiff then files for a default judgment on that, saying we want it to be established for liability that she is liable. And then we want the damages we're asking for, which is like $150,000. So step one happened. Before step two happened, then Frogan got lawyers, and the lawyers have now moved to set aside the default. And I've got other videos laying this out and the legal standard, but the court, there's a couple important things as we get into this to keep in mind. Number one, courts hate defaults. They do not like cases to end in defaults. So the bar to set aside a default is super low, super low. And it's very easy to meet. And then the second thing to keep in mind is you got to throw three things. Number one, you've got to show that there was not, that the plaintiff would not be prejudiced by the case continuing. You've got to show that you have a meritorious defense that should be adjudicated on the merits instead of through default. And number three, that you aren't culpable in the default, that you were not intentionally misbehaving when it comes to the default. So these are the points that are going to be made. Let's talk about this case. Hopefully folks are still with me. Am I still up? Okay. Sorry about that, folks. There was a technical glitch. 1 second, let me get the document back up. The button to end full screen mode is also the button to make the computer go to sleep. So at the risk of revealing my technical foibles, I accidentally hit the sleep mode on my computer. So fortunately, it looks like we are still here and we are still broadcasting and we are setting things back up. All right, let's go. Let's look at what Frogan says. So Frogan on Friday, she files her motion to set aside the default. Let's see what she says here. Now, let me add a little bit of context. So this is not the only case that Ethan Klein has brought. He's got other cases on this, and one other one is a case against a different streamer called Denim's. Denim's recently won. A judge found that Denim's commentary of the same piece of content was fair use and dismissed Ethan Klein's case. Frogan has now hired the same lawyers, and that feeds a lot of what we're going to see here. So this is Frogan. In Frogan's case, not Denim's case, but in Frogan's case, this is Frogan saying, Your Honor, please set aside the complaint. I've got some reasons. So the first thing they argue here is, and when you see TEI, that's Ethan Klein's company. So we can just see TEI means Ethan Klein, to keep it simple. Ethan Klein alleges Frogan's and other defendants' live streams were transformative, but contends their transformativeness lacked sufficient, lengthy, substantive, and accurate criticism to constitute fair use. So in other words, they're saying, look, even the plaintiff admits that there is some commentary here. And the issue for the court is whether that commentary is enough for the fair use defense to apply. And that's where we're going to get into these three factors. So is there good cause to set things aside? First, they say there's no prejudice. Second, they say that there is meritorious defenses, where that line of sufficient commentary is. And they're saying, no, Frogan has a good defense, that she has enough commentary for this to be a meritorious defense. And then finally, she was not culpable. Here is the issues that I'm seeing. This motion is very scant in terms of detail, far more scant than I would have expected. I read the Denim's motion, and I think I did a video on it. And if we do, we'll link to it above, or we'll link to it in the comments or in the description below. But Denim's motion, when they moved to dismiss their case based on fair use, there was all these details. They chronicled the amount of minutes that she was doing commentary on this video. They had numbers, they brought receipts, and it was a pretty strong motion. We see none of those details here, and it pervades a lot of this motion. So there's two things here. Remember, it's a very low bar to get over the hump to get the default set aside. But is there enough substance here to win? I think if it's like, it's going to be like this. It's going to be really close. It could go either way. I thought that this was going to be as strong of a motion as we saw in the Denim's case. And I thought it was going to be a pretty easy layup. And my last video on this subject kind of led down that path, that I think this is going to be pretty easy for them to set aside. I think it's like 50-50. I think Frogan maybe edges it out like 49% chance that she beats this. 51% chance she wins. It's very close because this is not a good motion. What is going to change my way of looking at this is how Ethan Klein opposes this. They've got to come back with some receipts. And if they do, I think Ethan Klein actually has a chance of beating this now. And this has gone back and forth for me. I thought this is an easy win for Frogan. And now I'm thinking it's not as easy as I thought it was going to be. So let's get into why. So the first factor, that prejudice, that's not even a thing here. The parties reach an agreement where each side got something. Ethan Klein's side got a promise, an admission of fact that they can use. And Frogan's side got this stipulation that there wouldn't be a fight on prejudice. So prejudice is not the issue. It's those other two factors. Does she have a meritorious defense? And was she, what's the word? Culpable. Was she culpable? On that second factor, meritorious defense, the question is not, is she more likely to win than not? Or is she definitely going to win? Does she have a better argument than Ethan Klein? That's not what the judge is looking at. The judge is just basically looking at, does your defense pass the smell test? If it does, he's going to give it to her. And then and so what she argues here, she says conclusorily, her use of the nuke is transformative. She paused the work throughout to add extensive commentary. Okay, but it's just boilerplate. It's transformative because she added commentary. Did she add enough? I don't know. They don't say. And she played it on 1.5 to 1.75 times. I don't know why they keep saying this. Like, that fact matters. Guys, I watch myself on 2x time speed. I know I talk slow. I watch myself on 2x speed. I hope you all watch me on 2x speed. I enjoy myself a lot more when you can speed me up. So I don't know why that matters, but they keep pointing this 1.5. None of that matters. What I want is receipts. I want to see the detail like we saw in the Denham's motion. How many minutes of commentary did she have? How many times did she pause the work? Was it 2 times or was it 200 times? It's a 100-minute film that they're reviewing. How many, like, give us some numbers, give us some receipts. That's what I was expecting, and I don't see it here. And so I was like, when I see this paragraph, I'm like, oh, this was my first indication that maybe there's something going wrong. Let me check my food real quick. Nope, we're still going strong. I think, let me look at this. I'm just flipping my log because one side is like burning and the other is not. So I flip it. So then both sides are burning because the bottom side is towards the hot coals. I hope you guys appreciate the random anecdotal barbecue advice I throw in between. Okay, so second factor, I'm like, I was hoping to see receipts. I don't see receipts. And then what do? So they give some platitudes, and then because it's the same lawyers, they just launch right into, by the way, there's this Denham case. It's in the same district, which is a relevant fact that another judge in Los Angeles granted the Denham's motion. And so you should just, because they won there, we should win here, is kind of the argument. It doesn't work. That doesn't work because what matters is the amount of commentary. And this is where I think Ethan Klein's side, if done right, if they come in with a good opposition brief, they can, no puns intended, they can nuke this opening motion with some receipts. Denham's and Frogan, they can say not the same case. Frogan has far less commentary, far more bathroom breaks where the thing just plays and she's not even in the room, whatever it is. But if they can come back with some receipts that show that the two cases factually are not the same, it dismantles this whole second factor. So finally, was she culpable or not? And she's got some more facts here, but there's still, I don't know. It's a better argument than the last factor. So they said, look, they try to lay out a timeline. First, they agreed to her deadline to respond to October 3rd. Remember, this is all about she had a deadline to respond to the complaint, and she missed that. The complaint's the very first thing that gets filed. It's got all the allegations in it. And you normally get 21 days to respond, to deny the allegations, to file a motion to dismiss, maybe to file counterclaims, however you're going to do it. But she hadn't done that here. So they're laying out this timeline. So there was an extension to October, and the parties were talking until April. And then here's the weird thing. On April 20th, on May 8th, Frogan's prior counsel ceased representing her. Well, that's odd. This is a civil case. She had raised money for her defense. Why did the lawyers stop representing her? And that happened 3 days. So Ethan Klein tells them on May 11th, we're moving for a default because you haven't responded to the complaint. So let's say that May 11th was a Monday. I don't know. Was it? Let me look. May 11th. May 11th was a Monday. My instinct. See, when you have practiced law for 15 years, you get spidey sense. So here's what happened. On Friday, Ethan Klein's lawyers probably sent an email and said, look, we're not negotiating anymore. You haven't responded to the complaint, and you got to respond by May 11th, on Monday. By Monday, you need to respond to the complaint. And so what does Frogan's lawyers do is the Friday before just says, I am no longer representing you. There wasn't anything filed on the docket. There wasn't a thing that said that they were withdrawing his counsel. Let me double check that. 1 second. I think I've got the docket here. Do I have the docket? I don't know if I've got it here. I don't have it handy. But bottom line, this May 8th, May 11th thing is super suspicious to me because Klein says we're going to file motion for default judgment on May 11th if you don't respond to the complaint. Or we're going to ask for default to be entered. Sorry. And so 3 days before, literally the business day before, the lawyer declares, I'm no longer representing you. I don't know. I need some details here. That sounds super shady to me. And I think a judge, especially if Ethan Klein's people call it out, I think a judge is gonna be like, what really happened here? Is this contrived? Did all this happen because like you guys set this up? I don't know. If I was Ethan Klein's people, there is a declaration that the lawyer put in, and they've now put this. I would consider deposing the lawyer under the argument that they've waived attorney-client privilege, because the lawyer does file something. This is like, I told them I couldn't represent him. There may be a waiver of privilege, and you might be able to depose the lawyer and get the emails and get what was said, because they don't say. So then this thing happened with the lawyer, and despite Frogan's efforts, none of which are explained, she was not able to secure new counsel until July 9th. Well, what happened is, accordingly, I guess in June, she went to this law firm, which is also Denham's law firm, and tried to contact them. And then a month goes by, so that's early June. Then early July, they come on as counsel. So a whole like more like two months go by between the the default and these lawyers coming in, and there's no explanation for what goes on other than some random generic statements. So let's walk through. So they get down deeper into the brief and they go into these facts a little more. So they say the negotiations failed by April 20th, 2026. And there was this May 11th date. In late April, Frogan's former counsel said they could no longer represent her due to his existing professional obligations and current caseload. That's bullshit. You don't get to play like, I have too many cases, so I can't represent you. I don't think that's a good excuse. I don't know how the judge is going to look at that, but that doesn't sound like a very good reason. Now, remember, the bar is incredibly low. So this may just be enough, but it's pretty threadbare. And so she immediately attempted to secure new counsel. She contacted these lawyers on June 5th. And then after securing financing, she retained the undersigned counsel on July 9th. Now, I don't know the timeline, but I thought she had a GoFundMe before June of this year. So there's a lot of gaps in this timeline that are not explained. I think that's the problem. And I understand that there are some statements she's made about this default that may come back to haunt her. And if Ethan Klein's lawyer is worth the money that Ethan Klein is paying them, that lawyer should be able to come back with some receipts that blow this out of the water. And so I think it's on real tenuous grounds. So let's see about when we get to the argument about the meritorious defense. And let's look at what they say. So they make a few points. First, the first thing that they start with, this is the middle of the brief. The district has already held a substantially similar allegations established fair use. Well, there are some similar allegations. Ethan Klein's guy his attorney did copy and paste a lot of the complaint. But let's find the first thing here. What I said before, each case, the Frogan case and the Denham's case, need to stand on their own merits. It's not enough to just say that there was another case where fair use was found. The facts of the two cases have to be similar. The amount of commentary has to be consistent and similar for that argument to hold water. And I don't know if it does or not, but what surprised me is the lack of detail. So they say here, the next major point, TEI pleads the same admission. So there's this statement in the complaint about that at times they were making transformative use. Okay. And the judge in the Denham's case liked that. That's a good fact that the judge highlighted. But just because there's some transformative fair use doesn't mean that that's sufficient for the defense to apply or to be meritorious. I do think that this admission is really bad. This should not have been put in the complaint, but it was in the complaint. Is it going to be enough? I don't know. It's not helpful to them that they had this in the complaint, that Ethan Klein's people put that in. They should not have conceded that there were moments of transformative use. This is the best argument they've got that Frogenstein has going for them right now is this bit here. And it was essentially a self-goal or self-own on Ethan Klein's part. They shouldn't have done it. But they say Ethan Klein admits that Frogan paused the nuke to comment, but complains that those moments frequently comprised of painfully pregnant pauses. And then they say, well, look, he said that same thing in Denham's. But here's the problem. In the Denham's case, these same lawyers, Frogan's lawyers are also Denham's lawyers. These same lawyers came in with receipts. They said she had X minutes of commentary. She paused the thing Y number of minutes over and over and over. They had solid details. There's no details in here. The balance of and so they talk about TEI's allegations. 40, and so they say here, 40 uninterrupted passages comprising roughly 70% of the nuke. That's they point to. And they say, oh, that wasn't good enough in Sabre. Again, they aren't making the same arguments as in the Denham's case. Sabre, by the way, is the Denham's case. The lawyers here are leaning very heavily on, we won the Denham's case, ergo we should almost by default win this case. It's not good because they're not tying it. They don't bring any kind of the statistics that they use in the Denham's case. Here they might be doing it because they say here, Frogan need not definitively establish fair use now. She need only raise a serious question. And so maybe they're keeping the facts out, saving them in reserve for down the road for how they're going to characterize it. And they're just saying, look, we don't have to give those statistics. All we have to do is show that there's a serious question about whether she's got a fair or meritorious defense. Again, it's a low bar, and I think maybe she's still got an edge, but this poor level of detail makes the fight a lot closer than I thought it would be at this point. So then finally, the culpability. The problem I have with the culpability, number one, they timeline has gaps in it, like we just went through. But number two, they don't address a lot of the things. She had a GoFundMe for litigation defense. That doesn't even come up here. She doesn't even mention it. They make it sound like she had to go out and raise funding when I think she might have already had funding. Now, put in the comments below if I'm wrong. If she didn't have funding till June, I thought she had a GoFundMe like way before then. But they leave that out. They don't mention any of the things she might have said on the stream, which I think she said stuff. And so she says Frogan did not make a conscious decision to ignore this action. I don't know. I'm not sure that that's right. And while they have this thing about the lawyer withdrew, there's nothing about the basis other than like, I just got too busy with other cases. I don't know. She had genuine uncertainty about whether she could fund that defense, but they don't say why. I just don't know. I don't know. I don't think this is very good. So there's a few, let me underscore this. They attached a few declarations to this motion, and those declarations are made under the penalty of perjury. So this is Frogan's under the penalty of perjury. And she says a few things. First, she says, Mr. Nikia, that's her first lawyer, were in constant communication. If they were in constant communication, I don't know if that fact really helps them. It kind of cuts both ways to me. She was in constant communication, and yet the lawyer didn't suddenly, without explanation, stopped having time to work on her case. And she says that there was a period of 8 months where they were engaged in settlement negotiations. But what happened during those? How many emails, how many phone calls, how many meetings? We don't know. Was it 2 emails over the course of 8 months? There's no details here. When you don't get the details, when you don't get the receipts, it looks a lot less persuasive to a judge. Judges don't give a crap about lawyers saying something like, for example, we were in constant communication. A judge is going to look at this, or more specifically, the judge's clerk will look at this, because clerks write a lot of the opinions. The clerk's going to look at this. Okay, you say you were in constant communication. Do you attach a document showing that? No. Do you include dates of the communications? How many times did you communicate? You say here that you were engaged in settlement communications over an 8-month period. How many times did you meet? How many? Attach some emails, include some phone records, something. You say it, okay, so that you were engaged in settlement negotiations. So what? Maybe you had one email. You've got to provide, to persuade a court, you have to provide facts. You can't just provide conclusions like this. And that's a problem. And then in late April, Mr. Nikia said he could no longer represent me in this matter. Well, why? And I get that gets a little close to privilege, but there's no detail here. And then on May 8th, 3 days before the default deadline, that Ethan Klein said, Mr. Nikia ceased his representation of me. I just don't know. We've got another declaration. So this is the one from the new lawyer, and they just include some hearsay statement. Despite Frogan's efforts to move quickly to retain new counsel, none of which, if we go back to Frogan's, none of which is laid out. She doesn't give any facts. She just says, I contacted the Frost LLP, that's the new law firm, in June. And then she says, once I was able to secure financing and clear all administrative hurdles. Look, guys, let me explain to you how quickly lawyers move when lawyers get new business. I got an email from a prospective client on Wednesday about doing a pitch for a case. By Friday afternoon, I had completed a full analysis, full workup of intellectual property infringement, and including what I think the likely best arguments are, the best defenses, and we had submitted a huge pitch. 3 days. I do not know why it would take from June 5th until July when this firm came on. Why did it take a month? There's no explanation for this. She has a vague statement about securing financing, which doesn't answer the question, because she already had a GoFundMe account or a GoFundMe donation, whatever we call it. She had a GoFundMe. So it doesn't answer the question. So I don't know. There's not enough detail here, and there's real questions that don't get answered that I thought would be easy layups. So then the last declaration is from the old lawyer. And what does the old lawyer say? The old lawyer says the same things. For 8 months, I talked to Ethan Klein's lawyer. We communicated multiple times. How many times? Show me something. Show me an email. Attach a log. Create a table that shows every communication, and then say the following table indicates each of the communications I had with Ethan Klein's attorneys over this 8-month period. They don't do that. It's just what we say, cursory, just very conclusory. Oh yeah, we talked. And then in late April, I could no longer represent Frogan due to my existing professional obligations and caseload. That doesn't fly with me, because you have an obligation when you take on the matter to make sure you have the time to do that. So I ceased representing Frogan on May 8th. This just smacks to me as a delay tactic. And this is how I think Ethan Klein's people are going to come back at this, is to say this was all just a contrived delay tactic meant to screw things up. So, all right, that's the Frogan case. That's where things are. Where do I think things stand with this default? Well, look, Frogan is benefited by the fact that it's an incredibly low bar. She's benefited by the fact that that the Denham's case was won, and those two facts help her. She is disserved by the lack of detail in this motion, by the gaps, the unexplained gaps, and by the significant amount of conclusory statements. So I do not, at the end of the day, think that this is a very good motion. It is far worse than I thought the motion was going to be. And I don't mean that just totally devoid of context. I looked at and read the Denham's motion to dismiss, and I thought it was an excellent motion by these lawyers. I thought they did a good job of bringing the level of detail necessary and highlighting the bad things in Ethan Klein's complaint that I felt undermined Ethan Klein's claim. Here, it almost feels like they dialed it in. We won the Denham's case, and so it just feels like they're dialing things in. It's not good, and it's not as good as I know that these lawyers can do, because I saw how good the lawyers did in the Denham's case, and I thought they did a great job there. So that's kind of where I think things land. Ethan Klein's response to this is in 2 weeks, and we'll see what they come up with. I think that this is a better, they're in a better position than I thought they would be at this point. So I think there's an excellent chance that Ethan Klein could hold this out. It's very hard, very low bar, but maybe they can do it. And because maybe the reason why there's not a lot of detail in this motion is because maybe they can't bring the level of detail. Maybe once you scrutinize the facts, it doesn't help them the way it did in Denham's. Maybe the facts are really bad. I don't know. I have not watched Frogan's React video. I can't even find it. It's like vanished. One of the few things that's vanished from the internet. So I can't find it. But maybe the facts are not beneficial to them, or maybe because the thing has been scrubbed from the internet, maybe they can't bring to bear the level of facts. I don't know. But at the end of the day, it's not as good as I thought. So I think we've gone quite a bit today. Let's check our super chats, and we'll start to wrap things up. So from Ryan for 10 joules, thank you so much, Ryan. Appreciate that. Again from Ryan, another 6 joules, saying chili. I do want to start doing chili. Look, I've made chili literally once. I went camping a few weeks ago and I made chili for the first time. I've never been a chili maker. I love barbecue. I love brisket, and I need to learn how to make brisket chili. So I'm with you. I'm with you on that one. The next one, Ryan, 2 joules. Thank you. Right, we've got a bunch of joules from Ryan. I don't know how joules work, but we've got a ton of them, and those are them. I do not have. It looks like we don't have really any other super chats. So, all right, folks. Well, look, I think that's it for today. And I really appreciate everyone being there. Thanks for sticking out through the little technical snafu. Second time using StreamYard here, and first time playing videos on Streamlabs. So there's a little snafu with me hitting the sleep button when I meant to exit out of full screen mode for the YouTube. With that, if you haven't yet, please hit the like, please hit the subscribe. And for folks on the replay crew, please drop some comments down below. I look at the comments. I spend hours after I post a video looking through all your comments. I try to respond to as many as I can. I answer questions in there. And if you haven't yet, we've got some really fascinating videos that just came out on the Reckless Ben case. There's one we published yesterday on the new RICO allegations. Bricks and Minifigs has been accused of RICO. So it's the first time there's been a formal allegation of that in a lawsuit. That's now happened. We do a full breakdown of that complaint. I will include it at the end of this video if you're on the replay crew. So please check that out. And finally, Reckless Ben has a new video unrelated to Legos. He's got a whole investigation he's done of something called the Provo Canyon School. And we are going to watch this, and we're going to talk about some of the legal issues in there. There's some fascinating legal issues that came up. So we are working on that. Be on the lookout for it, and we will talk to you all soon. So with that, folks, have a wonderful rest of your weekend. I hope everyone has a great day. I am going to go check this turkey, see how we're doing. Hopefully I'm going to be in a great place to eat that soon because I love smoked turkey. Talk to you all soon. Have a great day. Bye-bye.